One of the cool things about studying evidentiary law is the way in which each particular provision of the code connects to the other provisions of the code. And this is not immediately apparent when you go to look at it initially. If you read it through from beginning to end, the connections don't leap out at you. But there are a couple that I want to identify for you that you should think about, and you should always have it in the back of your head. And they have to do with the rights and the responsibilities of the parties that make the trial engine run. I'm talking about the counsel and the judge. Now, the rules that really talk about the counsel and the judge are primarily found in the 100, the 200, and the 300 series. But I want to focus you in on Federal Rule of Evidence 103, 104, and 105. 103 talks about the rights and responsibilities of the counsel at trial. As the lawyer at trial, you know from the standpoint of appellate jurisprudence that most evidentiary issues, if not raised during the trial itself, are waived on appeal. And the rulings of the trial judge are reviewed on purely evidentiary matters where there's not a constitutional implication, on a harmless error standpoint. Now let's think about that for a moment. The judge's rulings at trial are reviewed on an abuse of discretion standard. And even if you find that he abused his discretion or she abused her discretion, you still look to see whether or not the abuse of the discretion created an error that was or was not harmless when considering everything else that's been admitted at trial. What does this mean? It means that if I don't raise an evidentiary objection properly at trial and identify and lay it out, complete with an offer of proof as to why it is so important to the judge, that the judge, if they get it wrong, it's not the judge's fault. It's my fault as the counsel. Because I didn't properly inform the court, I didn't push the issue of a ruling on this question of evidentiary law prior to trial or during the motion to eliminate. And that's what 103 talks about. It talks about the duties of counsel to raise these sorts of objections and to properly identify them for the court so that the court is aware of the law that is applicable. Now, in order to do that as counsel, I've got to object or make a motion to eliminate, to exclude, or to admit. I make an offer of proof to the court as to what evidence I believe I have that is in support of my objection or motion. And then we argue the law, the application of the law to this series of facts. Sometimes we'll even bring in evidence in a motions hearing or outside the presence of the jury to hear my proffered evidence. And in a criminal case, I can even put a defendant on the stand for the limited purpose of a motion to exclude. And they can't be cross-examined about anything other than that particular area that they're testifying on. I have to get the judge to rule dispositively on any motion or objection that I make. So, for example, if I say, objection, hearsay, Your Honor. Oh, counsel, let's move on. Counsel, let's move on is not a ruling. Counsel, let's move on is I don't want to rule on this, let's just keep going. If the judge does not say overruled or sustained as to my specific objection, I have not made the record. And if I don't push the judge to say overruled or sustained, I have just waived the issue on appeal. And if I didn't properly inform the judge as to the reason for my objection, I am the one who is responsible for that as the lawyer, not the judge. So it falls on the lawyer's shoulders to do it properly. This has real impact when you think about it from a trial strategy perspective. It has real impact from an understanding of the evidentiary law perspective. And the socio-dynamics within the courtroom are important too. What if you have a judge who never rules? Many of us who've practiced have had that experience. I had a judge once who could not make a ruling if you had overruled written on one hand and sustained on the other and said, Your Honor, just pick a hand. Why? Because he didn't want to make a decision. Why did he not want to make a decision? Because if he did not make a decision, I, the lawyer, had waived the issue on appeal. You've got to be aware of that, and that's the way 103 worked. Now, for a long time, it was an open question of law as to whether or not, if you raised the issue in a pretrial motion, and the judge ruled dispositively on it, whether or not you had to raise it again during the case in chief to preserve it on appeal. And there was a split in the circuits on this particular issue. I'm happy to tell you now that there's been a change to the Federal Rule of Evidence 103. It's not even a relatively recent change, almost a historical change now. And once you have gotten the judge to rule dispositively, the issue is preserved. Why is that important? Because I could have something that I'm fighting over that I really don't want in because it's going to hurt my client badly. And if I lose, the other side presents it. If I fight over it again when it's presented the second time in front of the jury, I am now underlining, highlighting, and putting exclamation points beside this fact that I've already determined is bad for my case. I don't have to do that anymore under 103 as it currently works. Now that's a nice look at Federal Rule of Evidence 103 and the practical way in which it impacts the actions of attorneys at trial. Let's take a look at our next clip at Federal Rules of Evidence 104 and 105, and we'll talk about them. All right?